Hi, I'm Steve Richardson. If you're getting divorced here in New Jersey and you're thinking about filing bankruptcy, you might be asking yourself, what obligations in my divorce can I discharge and which would be non-dischargeable? Well, one of the things you need to consider is, do you have a prenuptial agreement? Did that agreement create obligations for you to your spouse or former spouse? If that's the case, you need to be careful in bankruptcy, because if that obligation that's in the prenuptial agreement is then incorporated into your divorce decree, then a bankruptcy judge later on may declare that to be non-dischargeable because it's in the nature of support. Now, the bankruptcy courts can make their own determination. There have been cases where the family court enters an order, creates an obligation, but doesn't say anything about whether it's for the purposes of support. Or it may even say it's not for the purposes of support. But a bankruptcy court judge can make his or her own determination. The important things to look at are the relationship between the parties. Are they married? Was the obligation for the purposes of support? Was that support obligation incorporated in some sort of family court order? And is that obligation currently being held by the receiving spouse? In other words, that spouse didn't assign it to someone else. Well, that bankruptcy court judge can make his or her own determination. So, when you're talking to a bankruptcy attorney, make sure you talk about any prenuptial agreements, bring it up, any other obligations that you may have as part of a divorce decree, or that might become part of a divorce decree. So, if you live here in southern New Jersey and you're thinking about filing bankruptcy and you might be worried about how that might affect obligations in your divorce, please feel free to give my office a call. I'd be happy to sit down with you in my Woodbury office, look at your situation, and see whether bankruptcy is right for you.